Good morning, Council. Justice Lowy is recused from this matter. Chief Justice Gantz is participating fully in this decision. Mr. Keneally, if you could call the case, please.
SJC 12878, Commonwealth v. India Boger, and SJC 12900, Commonwealth v. Daniel Ramos Cabrera.
Thank you. Mr. Madison. We have to get you off mute, Mr. Madison. There we go.
Apologize, Justice Gaziano. Please point on behalf of India Boger. This case raises two issues, interrelated issues arising from the strict liability standard, the strict liability aspect of the school and park zone statute. The first issue is whether the Commonwealth must prove that land alleged to be a public park is owned or maintained by a governmental entity. And the conclusion that this is an element of the Commonwealth's proof flows directly from the language the legislature used in the statute. The legislature used the term public park. And as this court noted in the recent decision in Mata, park standing alone includes, as a usual and accepted meaning, maintenance by a city or town. So when the legislature combined a modified park with the word public, it evinced a clear intent to limit the reach of the statute to publicly owned or maintained land. And to argue, as the Commonwealth does, that the legislature evinced a unambiguous intent in using the term public park to reach privately owned land is contrary to the text of the statute. It's contrary to established canons of statutory construction and unnecessarily raises constitutional questions of adequate notice and arbitrary and discriminatory enforcement. The second issue raised by this case is whether an entrapment defense must be necessary in certain school or park zones prosecutions where law enforcement affirmatively brings a underlying drug offense into a park zone. And the facts of this case illustrate why such a defense is necessary in these circumstances. In this case, the detective solicited a drug transaction, said that the exchange needed to occur by him, proximate to him, and selected himself a location that he believed to be in a public park.
Right. Now, Council, may I interrupt you?
Absolutely.
So one of the things when I was looking at the I'll probably say the name wrong, Salino case or Solon?
Salatino, I believe.
Salatino, okay. And that one seemed to me to be really more concerned with the amount of the drugs involved, not necessarily the location. Is that correct?
That's correct. The cases the Commonwealth cites, and I cite in my reply, Salatino, Garcia, and Ortiz, this triptych of earlier SJC cases. Right. Those were all about the weight.
The weight. And I understand that weight certainly can push you into a higher category, so that might make it into a, you could argue it's a sentencing factor entrapment. Is that what the word, or manipulation? Sentencing factor manipulation is the language that's used. So if you were to apply that here, sentencing factor manipulation, how would you have what would be the steps you would go through in a trial to get that defense in front of the judge properly?
So I feel like the terminology here can be a little confusing. I know the courts have tried to pull apart quote unquote sentencing entrapment and sentencing factor manipulation. In my brief, I articulate the contours of a suggested entrapment defense that includes this idea of that the defendant's predisposition matters. And I think under how the distinction was articulated in Salatino, this would be more of a sentencing entrapment version. But again, I don't know that these different labels help particularly. But what I suggest in my brief is very similar structure to the affirmative substantive defense of entrapment. The defendant would have to make an initial showing that the conduct of law enforcement caused the underlying offense to occur within a school or park zone, and then the burden would shift to the Commonwealth to disprove that the law enforcement caused it to occur in the protected area, that they would disprove that law enforcement, their primary intent was to cause the enhanced sentence, or to show predisposition on the fact, predisposition that the defendant was predisposed to sell within this protected area.
One more question, and then I'll turn it over to my colleagues. Do you have any cases where that has been successfully used in Massachusetts?
An entrapment defense, Justice?
Yes, on sentencing.
It not successfully used. The closest is the appeals court decision in Lawrence, where both the majority opinion and concurring opinion said that if, well, the concurring opinion went slightly farther than the majority opinion, but both suggested that that they may be inclined to recognize this in the specific context of the school and park zone statute.
Can I ask a question about the public park issue? Didn't we say in MATA that the instructions were fine, and weren't they very similar to the ones that were used here?
Correct, Justice Budd. In MATA, I believe in a footnote, it had a very similar instruction to the one that's used here, which is based on Commonwealth v. Davie. The issue arises because in MATA, it was, from all appearances, undisputed that the land was owned and maintained by, I believe it was the City of Holyoke Parks and Recreation Department. Here, that is not the case. The whole issue was, the defense position is there was no evidence of government ownership or maintenance. And so while the instruction may have been sufficient in MATA, where that was not an issue, here that was plainly an issue. All the parties knew that this was an issue. And what the instruction was, you can consider this multifactorial test, but it didn't make government ownership or maintenance an element that the jury was required to find. That's the error that we're arguing here.
But didn't we also say in MATA that there was no need to prove title?
That's also correct. I interpret that language as being more, for what I understand MATA to be doing is to create a two-part definition as to public park. One part, which is the government ownership or maintenance, and then the other part, which is dedication and use. I interpreted that language about title to be focused on the dedication and use portion of that definition, which was the focus of MATA, because as I said before, it was essentially undisputed from all appearances that government ownership and maintenance was satisfied in that case.
If we go back to the statutory purpose, which is to protect children as articulated in our case law, in some legislative history, isn't the gravamen of public park or the issue of whether or not the public is invited, i.e. we're going to have children here, as opposed to whether it is owned by a cooperative or a conservation agency and maintained by that same agency? Similar to what Justice Budd asked about title, aren't we really concerned about whether the public is invited and thus making it a public park?
Well, to the extent you're correct, Justice Gaziano, that the court has articulated that the legislature's purpose of this was to protect children of the school and park zone statute. Of course, that begs the question as to the entrapment issue of why the detective just—
Let's stick with the first issue first. Let's
where children might be. But
stick with my issue. Thanks.
Getting to your point, it goes back to the language of the statute. The legislature could have used park. They decided to modify it to be public park, and that makes a lot of sense because there needs to be limiting factors to what can be a park, particularly in a strict liability aspect. In my principal brief, I cite some of the things that could be parks under this broader definition suggested by the Commonwealth, which opens up the statute to much broader application than I think is generally understood, and is contrary to this court and the legislature's recognition that the school and park zone statute, as it was originally enacted, had discriminatory impact on urban communities. And so the need for limiting factors as to what a park is very important in a strict liability context.
Other questions? Thank you, Mr. Madison.
Thank you.
I think it's Ms. Gleason's up.
Yes, good morning. May it please the court. Deirdre Gleason on behalf of Mr. Gadiel Ramos Cabrera. As you were discussing with my brother, a park in this context is an area that was intended by the owner for enjoyment and recreational use by the public. It's also a place where children are likely to be present in order to fulfill the purpose of this statute, which is to protect children. This court in Mata last year found that evidence of ownership does not go towards intent for people to recreate. And it also found, you also found that recreation can occur by happenstance instead of as a result of the intent of the owner. And here, in my case, there was no direct evidence that the city of Holyoke intended for Valley Arena to be used for the public to recreate. And in fact, there was uncontested evidence of contaminated soil that was discovered nearly 30 years ago that essentially prohibited the city from having, from being able to have the public recreate there. They were prohibited from having, quote, any activities or turning the soil.
But wasn't there a basketball court there or something like that?
There was, Your Honor, but the Ms. Shepard, who was the director of Parks and Recreation and had been there for 30 years, described the basketball court as a half basketball court in bad disrepair.
Well, counsel, is there any requirement that the park be kept in good repair? I mean, or do you have to have signs saying public stay away?
I think that the requirement is to have the city intend to have people come there. And this Valley Arena used to be a park for sure. 30 years ago, they were actually installing playground equipment.
Well, actually, I think wasn't this the debut of Rocky Marciano's professional fight, this location?
I
It was quite famous.
Uh-huh. Okay.
I'm sorry, I do not,
Okay.
I don't know that reference. So 30 years ago, they were installing playground equipment. So you're correct in that it was once a park. This was once an area where the city of Holyoke intended for people to come and recreate, because there is a basketball court there, but it's a half basketball court. And Valley Arena was described by Ms. Shepard as blight, frightful. When asked,
Could I ask just a question here about the basketball court, the half basketball? Is there any evidence that it was used?
yes, there was testimony by Ms. Shepard and my client that they have seen people play basketball there sometimes.
Okay.
So if a bunch of 10-year-olds came to Valley, and unfortunately, that's the only recreational activity they have in the city, isn't that the goal of the statute, to keep drug dealing away from the 10-year-olds playing basketball?
It certainly is, Your Honor. However, this recreation can happen by happenstance. So there's a half basketball court there, but the city is clearly not maintaining this area. They have clearly abandoned it. I mean, it was identified as being almost abandoned by Ms. Shepard. And I cited some cases that give good examples of cities or towns doing things that indicate that they are inviting the public, or they are doing things that showing that they intend for the public to recreate there. We have the case where they hosted a baseball game, a high school baseball game, on a full baseball diamond. So that indicates that they are.
That can't really be the standard, right? I mean, if they've got a half basketball court up there and they haven't knocked the court down or put up a sign saying, public stay out, this is dangerous, kids are going to use, they're going to use the half court. That's that's what their perception is going to be, right? I mean, we can't have a standard that is a well-maintained park, can we?
Well, and I'm not saying that it needs to be well maintained, because certainly there are, there are various levels of a park and the maintenance of a park. But I think here it's pretty clear that the city stopped maintaining this 30 years ago. And it was, again, it was described as blight. And this community has this area that really is not a safe place for children. It's contaminated by soil. It has contaminated soil. The city itself has not done anything for nearly 30 years to maintain it or make it a place of enjoyment, make it a place for individuals to recreate. And it's, not only do they have this blighted park in their community, but it is also being used to enhance sentences of the people that live there. So I think that it just doesn't, I think that there's different levels of what, what we would be looking for the city to be maintaining a park. But I think here it's pretty clear that they were not doing that.
You have a few minutes, Ms. Gleason, if you want to wrap up.
Okay, just briefly about the jury instruction. I did have that was another issue where the jury was not instructed as to what it was that they were supposed to find. This, as you know, this court found that it is for the fact finder to find whether or not a park falls within the definition of the statute. And in my case, the instruction did not give them any indication that they were to decide whether or not the city intended for Valley Arena to be a place for recreation and enjoyment by the public. They were also not instructed that they were to determine whether or not Valley Arena would likely have children present, and whether or not a designation of that would be consistent with the purpose of the statute. I did see in Mata, there was a more detailed instruction as well as the Boger case that you heard before me. But in my case, it was simply, you're to find whether or not this is a public park and if it was within 100 feet of the drug transaction. So this was a live issue that the jury was not informed that they were to make a decision about. And admittedly, the trial counsel did not object to the instruction, and he should have. But the error created a substantial risk of miscarriage of justice because the jury was not informed about what it was they were supposed to be deciding. And the Commonwealth's case about whether or not Valley Arena was a park was underwhelming. And again, Ms. Shepard's testimony undercut most of their case about that.
Thank you, Ms. Gleason.
Thank you.
Ms. Mello. We'll have to unmute first. Thank you.
May it please the court, Emily Mello on behalf of the Commonwealth. The Commonwealth would ask this court to find that ownership or maintenance by a governmental entity is one of several factors to be considered by the jury in determining whether a particular tract of land is a public park. And I think if the court looks at the dictionary definitions, the legal definitions, and prior mass case law, they'll find that the tenor of these definitions suggest, the definitions of both public and park suggest that government entity or ownership and maintenance by a government entity is but one factor to be considered. Particularly if the court looks at City of Salem versus Attorney General, they do say a public park normally is an open space maintained for the recreation and pleasure of the public. And I think that that is really the crux of the definition, is whether a particular tract of land is maintained and held open to the public for public recreation. And that really gets to the intent of the legislature, to keep drug dealing away from spaces where the public is recreating and where children may be recreating. As to the second issue, the Commonwealth would ask that the court declined to recognize sentencing entrapment in this context. The appeals court previously declined to recognize sentencing entrapment in park zone, school zone context. And the Commonwealth would ask this court to uphold that.
Okay. Counsel, let me interrupt
Please.
you for a minute. Going back to the park, what evidence was there in the record that there were any children using this park?
There wasn't evidence specific to children. There was evidence that people would use the park for walking, hiking, running, fishing, and things like that. It was
Okay.
a park with hiking trails and ponds. It was a public recreation space. There was no fee to recreate there, and that it was open to the public for enjoyment for these purposes.
Okay, and now going back to the sentencing enhancement or the sentencing entrapment or sentencing factor manipulation, is it your position that we have not yet adopted that doctrine at all?
The court has not adopted that doctrine. It has actually repeatedly rejected the doctrine. It's rejected it in terms of weight of drugs, and the appeals court has rejected it in this context.
But do you see a difference between the weight of drugs versus where a police officer brings a defendant or prospective drug seller if they ask them to meet them in a certain location?
Certainly there's a difference, but I think that it is analogous. With respect to trafficking and weights of drugs, often the police officer or undercover officer will ask for greater and greater quantities. And essentially what the cases have said and what some of the federal cases that Massachusetts has cited say is that it's designed to test the limits of the defendant's inclinations. The defendant is essentially ready and willing to sell those quantities. I think that
That's not really applicable here, where there's no, it's not like the let's buy the drugs first on the street corner nowhere near a park, and then we'll buy it in a park. I mean, that's not what happens.
correct. It's certainly different, but I would say that it's analogous because it tests the criminal inclinations. They say, can you meet me at this location? And the defendant is ready and willing to go to that location, which is a park.
Well, should we take another look at this if that's the case? Because I understand with weight, it shows the ability of a defendant to access a gram and then onward upwards when they work the person and they get to 100 grams, right? That's what can happen in an undercover capacity. But here in a one-shot deal, we have a police officer saying, I picked this park for a particular reason. He's not allowed to be examined by defense counsel to say, hey, one of those reasons could have been the other, what is it, 18 months tacked on?
It's 2 years.
2 years, the other 2 years tacked on to the sentence. That there's no inclination. It's basically happenstance picked out of the hat by the cop, knowing that he's going to have a sentence enhancement.
And so I would point the court to the language that's used in Garcia and citing United States v. Connell, where they say, by their nature, sting operations are designed to tempt the criminally inclined, and a well-constructed sting is often sculpted to test the limits of a target's criminal inclinations. And I think that's what's happening here. And I also
What if the undercover cop said to him, meet me at this particular corner and there's this huge hedge, and this guy's coming from Boston going all the way out to the sticks. What if there's a huge hedge and the guy doesn't know that, oh, by the way, across the street is a school?
And I think that's exactly the point that the legislature has made and intended by continuing to keep this crime a strict liability crime. And the detective here, he put out an ad on Craigslist. That ad is going out to the entire world. The defendant chose to respond to that ad and come to the location.
But and I'll get to Justice Kapker in a second, but didn't we recently say when you have these happenstance type issues, which, you know, the person stopped at the stoplight next to the school, that's a fissure in the strict liability? Why wouldn't we say when the police officer picks to someone who's not from the area, go to this particular place and it happens to be a sentence enhancer, that can be something the jury can look at?
Well, I think the court is referring to Commonwealth v. Peterson, and in Peterson, the court was very clear that it was specific to those specific facts and that specific crime. And the crime there was possession with intent. And I do think that that is different. It's possession with intent, and you happen to be traveling through a school zone when you are the passenger in a car. When you are actually distributing the drugs in the park zone, I think that that is a far cry from what we have in Peterson. And certainly, whether or not the defendant was familiar with the area, she asked for directions, she asked for additional money for her driver. She was perfectly ready and willing, which is that language that the court uses repeatedly with respect to these types of situations. And I'd point the court as well to United States v. Glover, where they use that language, that the defendant is ready and willing to commit the crime in this particular instance. And it happens to be in a park zone. And that tests the criminal inclinations, and that defendant was willing to do that.
Justice Kapker.
Two follow-up questions to Justice Gazianos. Don't we want to discourage the police from bringing drug transactions into parks? I mean, I think Judge Chapman's clearly right on point on existing law, but so that's my first question is, don't we want to discourage the police from doing this? And secondly, if we're changing the law here, how do we apply this prospectively? How does this work here? If we think that this is a change we should make, how does it play out here, given that the trial judge is probably correct that this was not the law at the time, but it may be something that we need to adjust?
So I'll take that question in two parts. As to the first part, certainly I understand the court's concern. I would say that here there was a question put to the detective about, and the judge did allow the defense attorney to ask this question about why he chose that area. And the reason that he chose that area was he said he had received multiple complaints for suspicious activity in that area. And I would also point out that the ad did not just solicit.
Trying to figure out whether it's the same person selling there. I mean, it just seems like drug deals that go bad can get dangerous. Do we really want to encourage the police to do that? But can you switch to the second question?
Sure.
If we look at this as a change, how does it work out in this particular case?
I think if the court were to accept the defendant's proposition and recognize sentencing entrapment in this school zone, park zone context, it would need to be applied prospectively. Often there are changes in the law and similarly when the court narrowed the school zone statute, I believe with respect to 1,000 to 300 feet, with respect to the school portion.
You may think we legislate, but the legislature actually did that.
I know. Thank you. But that was applied prospectively, and I think that shows that the intent would be that any change that the court would be inclined to make should also apply prospectively.
Any further questions? Thank you, Ms. Mello. Mr. Lynch, finally.
Good morning. May it please the court, Travis Lynch, District Attorney for Hamden for the Commonwealth. In the Ramos Cabrera case, the evidence plainly shows that Valley Arena Park is a park, as this court has defined it in MATA and under Section 32J. The city intended that the park be used by the public for recreational purposes by leaving it open and having placed inside of it a basketball court and a swing set. And there is testimony from Teresa Shepard that people use the park and people go to the basketball court. So nothing else was required to prove that Valley Arena Park is a park within the meaning of the statute. And I'll try to answer you, and I'm ready to start taking your questions now.
Okay, counsel, can you address the sentencing factor manipulation component of this? Since we have here somebody who really, was drawn to this area by the police officer, why is that not a good case for sentencing factor manipulation or sentencing entrapment? They wouldn't have been there otherwise.
That's not actually raised in this case, Your Honor, but I believe that the evidence tended to show that the trooper encountered the defendant. They then drove a short distance, and then the defendant went into the house at the building at 556 Bridge Street, and then came out, and then the drug transaction happened nearby that location. And
Okay.
so I think there are drugs inside of 556 Bridge Street. So I don't think this is not a case for entrapment.
All right.
It's not raised. Yes.
But you did, well, then tell me about the jury instruction. Is it the jury instruction issue? That is the, what's your main, I'm mixing these two cases up. So are we just dealing here with whether this is a park and basically whether the instruction was right?
Sure. So I think that the way that in this case, the instruction was just the instruction given from the district court model jury instructions. The other case, that judge gave the Judge Ford instruction from that.
Okay.
But in this case, all that the jury were told was, if you find that he distributed, then you have to determine whether he did it within 100 feet of a park. And I would tend to say, yes, the instruction doesn't quite define what a park is, but as the appeals court noted in Davey, the statute's not void for vagueness for not defining what a park is. And the sources of, the source where this court took, the word park is used in its ordinary sense. Everybody knows what a park is. It's not a statutorily defined term. So the jury doesn't need to be told what factors in particular they need to consider when determining whether a park is a park, because everyone knows as a matter of common sense what that is. And especially here, where the defense did not object to the instructions as given. He didn't request the instruction that was given in the Essex case or in Matta, which unfortunately he didn't request such an instruction. That would obviate this issue, but the instruction as given does not create a substantial risk because the burden is clearly placed on the Commonwealth for all elements of the offense. So
do you think if he had requested the specific instruction and it was rejected and this was given, do you think that would have constituted enough grounds to reverse the case?
It may have constituted prejudicial error, but I'd also point to the fact that the way that the defendant litigated this case at the trial was that he mostly attacked the adequacy of the investigation. He was trying to show that, well, there's reasonable doubt whether the police actually bought drugs from the defendant. That was the focus. That was the focus of the argument before the jury. The park matter, I think it should become clear from the transcript. The defendant was trying to knock out the park charge on a required finding for not guilty motion. And the judge rightly concluded that it was a jury question and not, and that the evidence was not legally insufficient at that time. And you'll note in closing argument by the defense, he devotes maybe a couple sentences to talking about the park, and it's a very limited argument. And also, the defendant agreed with the prosecutor's characterization of the park as a park. So everyone is saying that this park is a park. So I would say that on the particular facts and circumstances of this case, there's not a substantial risk, which is not to exclude the possibility that in some other case where the instruction was requested and was not given on request, that would not be prejudicial error. I guess it's sort of like how, say, in a specific unanimity case, there seems to be a dividing line in a lot of those specific unanimity cases. If you request the instruction and it's not given, it's prejudicial error. But if you don't request the instruction, it's not going to create a substantial risk in the vast run of cases. And so.
Okay, thank you.
Any further questions for Mr. Lynch?
Thank you.
Counselor.
Thank you. I'll rest on my brief.